Embarking on a real estate journey within the European Union presents a unique set of procedures and regulations. Each country within the EU has its own distinct legal framework, making the process both intriguing and complex. Unlike some countries with more streamlined systems, the EU, with its diverse legal landscape, offers a fascinating study in property acquisition. The differences in legal requirements and customary practices from one country to another can be quite significant. This essay serves as a guide through the labyrinth of European real estate transactions, focusing on critical aspects like preliminary contracts, the role of notaries, and the final transfer of ownership. Understanding these elements is crucial for anyone looking to invest in European property. We'll delve into the intricacies of this process, aiming to equip you with the knowledge to navigate this exciting yet complex world. From the initial search for a property to the final handshake, each step is filled with important decisions and legal considerations. Buying a home, whether a charming Tuscan villa or a sleek Berlin apartment, is a significant life event. It represents not just a financial investment, but also a personal milestone and a new chapter in life. It's a journey filled with anticipation, careful planning, and, let's be honest, a fair bit of paperwork. Each document and signature brings you one step closer to owning your dream property. Understanding the legal framework and customary practices of each country is paramount for a smooth and successful transaction. This knowledge helps prevent potential pitfalls and ensures that all legal requirements are met. Throughout the EU, the real estate transaction process emphasizes security and transparency. These principles are designed to protect all parties involved and to foster trust in the real estate market. This approach provides safeguards for both the buyer and the seller, ensuring a fair and legally sound transfer of ownership. It also helps to build confidence in the transaction process, making it more accessible to international buyers. By illuminating the intricacies of this process, we aim to demystify the world of European real estate, empowering you to make informed decisions every step of the way. Whether you're a first-time buyer or an experienced investor, this guide will provide valuable insights to help you achieve your real estate goals. Imagine finding your dream home in the heart of Paris. The charming balcony, the bustling street life below. It's perfect. But before you start measuring for curtains, there's a crucial step: the preliminary contract, often referred to as a compromis de vente in France. This legally binding agreement, a cornerstone of most European real estate transactions, marks the first serious commitment from both the buyer and the seller. It's not just a handshake, it's a detailed document outlining the property's specifics and the terms of the sale. The preliminary contract typically includes the agreed-upon purchase price, the payment schedule, and a deadline for the final sale. It may also stipulate conditions that need to be met before the final contract is signed, such as obtaining financing or a satisfactory property inspection report. This initial agreement provides security and clarity for both parties. It prevents gazumping, where a seller accepts a higher offer from another buyer, and safeguards the buyer's investment before the final deed is signed. Understanding the importance of this preliminary stage is vital for a smooth and successful real estate journey in Europe. While the concept of a preliminary contract is common across the EU, its implementation and specific details can vary significantly from one country to another. These variations often reflect local legal traditions and customary practices. For instance, in Germany, the preliminary contract, known as Vorvertrag, is often even more detailed than in France. It may include specific clauses regarding potential defects in the property and the distribution of responsibility for addressing them. In contrast, in Italy, the compromesso might be less comprehensive, with the final contract, Rogito, containing more detailed information. Understanding these nuances is crucial for buyers and sellers to ensure their interests are protected. Consulting with a local real estate agent or lawyer familiar with the specific regulations in the country where you're buying is essential. Their expertise can help you navigate the intricacies of preliminary contracts, ensuring a smooth and successful transaction. Remember, what seems like a minor detail in one country could have significant legal implications in another. Section 4. Legal ramifications and safeguards. Signing a preliminary contract is a significant legal step, committing both parties to the outlined terms and conditions. This initial agreement sets the stage for the entire transaction, making it crucial to understand every detail. While it provides security, it also carries certain legal ramifications that both buyers and sellers must understand. These ramifications can have long-lasting effects on both parties, influencing not just the immediate transaction, but future dealings as well. For buyers, backing out of a preliminary contract without a valid reason, such as a failed property inspection revealing significant undisclosed issues, could result in financial penalties. These penalties are designed to compensate the seller for the time and effort invested in the transaction. They may forfeit the deposit paid upon signing the contract, which can be a substantial amount, often around 10% of the purchase price. This deposit acts as a form of security, ensuring that the buyer is serious about the purchase. Similarly, sellers who withdraw from the agreement without a legally justifiable reason, such as the buyer failing to secure financing as stipulated in the contract, could face legal action from the buyer. This legal action can be both time-consuming and costly. They may be held liable for damages beyond the deposit, potentially even facing a lawsuit to enforce the sale. This could include covering the buyer's legal fees and any additional costs incurred due to the breach of contract. Understanding these legal implications underscores the importance of careful consideration and due diligence before signing a preliminary contract. Taking the time to thoroughly review the contract can prevent future disputes and misunderstandings. Seeking legal advice is highly recommended to ensure you fully comprehend your rights and obligations. A legal advisor can provide valuable insights and help you navigate the complexities of real estate transactions. Remember, a well-drafted preliminary contract protects both parties, providing a solid foundation for a successful real estate transaction. It ensures that both the buyer and seller are clear on their commitments, paving the way for a smooth and mutually beneficial deal. Section 5. The notary's role ensuring validity and security. In the world of European real estate, the notary plays a pivotal role, acting as an impartial public official who ensures the legality and security of property transactions. Unlike some countries where lawyers handle the closing process, in most EU nations, the notary holds this crucial responsibility. Appointed by the government, notaries possess extensive legal expertise, specializing in property law, inheritance, and contract drafting. They are responsible for verifying the identities of the parties involved, ensuring their legal capacity to enter the contract, and confirming that the property's title is free from any encumbrances. The notary's involvement goes beyond simply witnessing signatures. They meticulously review the purchase agreement, ensuring its compliance with all applicable laws and regulations. They also explain the terms and conditions of the contract to both parties, ensuring full transparency and understanding. This rigorous process provides an additional layer of security, safeguarding against fraud and potential disputes. The notary's impartial oversight contributes significantly to the stability and trustworthiness of real estate transactions across the EU. Section 6. Notarization in action: France, Italy, and Spain compared. While the core function of a notary remains consistent across the EU, the specific procedures and nuances of notarization can differ significantly from one country to another. Each nation has its own unique legal traditions and requirements that shape the role and responsibilities of notaries. Let's delve deeper into the fascinating variations in three prominent European nations: France, Italy, and Spain. Each of these countries has developed its own distinct approach to notarization, reflecting their individual legal cultures and historical contexts. In France, the notaire enjoys a particularly influential role. They're not just legal professionals, but also public officers appointed by the state, which grants them a high level of authority and trust. They are involved from the preliminary contract stage, ensuring its legal soundness and often holding the buyer's deposit in escrow. This early involvement helps to prevent potential legal issues and ensures that all parties are fully informed and protected. The final signing, or acte authentique, takes place at the notary's office with both parties present. This formal ceremony underscores the importance of the transaction and provides a clear, legally binding conclusion to the process. In Italy, the notary, known as notaio, plays a similar role, overseeing the final signing of the rogito, the deed of sale. The notaio's involvement is crucial in ensuring that the transaction complies with all legal requirements. Interestingly, in Italy, it's mandatory for both the buyer and the seller to have their own legal representation during the signing. This requirement adds an extra layer of protection for both parties, ensuring that their interests are adequately represented and safeguarded. Spain also mandates the involvement of a notary known as notario. The notario's role is to ensure that the transaction is legally sound and that all necessary documents are properly executed. However, unlike France, where the notary often handles the property registration, in Spain, this task falls under the purview of the land registry. This division of responsibilities can affect the overall process and timeline of the transaction. These examples highlight the diverse approaches to notarization within the EU. Each country's system has its own strengths and challenges, shaped by its legal traditions and regulatory environment. Understanding these subtle yet significant differences is crucial for navigating the legal complexities of real estate transactions in each country. Whether you're buying property in France, Italy, or Spain, being aware of the specific notarization requirements can help ensure a smooth and legally sound transaction.